Welcome to Self-Represented in Family Court. Your host, Tracey Bee. So, here we discuss strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need.
It's about thinking for yourselves. It's about coming up with answers for yourself, because your case is nothing like the person next to you. Even though it might seem that way, the judge is different, the lawyers are different, even the environment is different. Everything is different. So for you, it's ideal for you to come up with a strategy, with a game plan as early on as possible so that you can move through family court with as much ease and success as possible. The law matters maybe 20% of the time. Procedure matters way more than law, but strategy is the overall underlying basis, foundation for you and your case to proceed through family court successfully. What is strategy? Strategy is coming up with a solid game plan, but it's not just a game plan. It's a game plan that you set out for yourself. You set goals, you want to reach them, and you want to implement tactics that's going to allow you to reach those goals when you have a case going on in family court. What is your overall objective? Is it to get custody? Is it to split custody? Is it to get property that you are entitled to? Is it to get more time? Whatever it is, you should have a specific goal. You should know why it is you're aspiring to reach those goals. That's where strategy comes in at. So many people go to court and fly blindly. They just go there asking for anything under the sun with no rhyme or reason because they heard someone else say in a Reddit group or a Facebook group, that's what they should do. And to me, those are the ones that I cringe because they don't even have a plan, let alone a game plan or a strategy. They're just flying blindly. They're just going in there and throwing out whatever they think, whatever comes to mind, and expect something to stick. And family court is not the place to do that. Because of all of that, you need to make a plan knowing that all these things exist, and you're going to factor those into how you come up with your overall game plan, how you're going to reach your goals, knowing that family court is very biased. And you need to know that. The more you know those truths and the more you factor those into your goals or your overall game plan, the better chance you have of getting exactly what it is you want. And so that's what strategy is. It's extremely important if you really want to get exactly or even close to what it is you want in family court. It's very important. I can't stress enough how strategy is much more important than knowing the law or understanding procedure. Because if you have a strategy, you'll know when to look for a procedure, or you'll know when law applies and when it doesn't. So that's why it's extremely important to come up with a strategy and to come up with the tactics or the steps that it's going to take for you to fill in all the blanks in your game plan. Strategy should apply to your personal life. I always have a strategy for my personal life, and I assess what's going on with me right now. I assess everything, financially, mentally, emotionally, everything. And then I identify what the obstacles are, what the challenges are going to be. I always take time to identify what could possibly come up to derail what it is I'm setting out for myself. And then I do my own research. I research and I investigate and I dig, and I do that with everything. And then I brainstorm. I take everything that I assessed, everything that I identified, all the research and the information that I found, and I sit and I brainstorm what I'm going to do with it, how it works, what's really a threat, what's really not a threat, what's really an opportunity, because some things that looks like a threat are actually opportunities. And then I plot my next move. And I do that. Maybe I might do it too much actually, but I do it. I plot everything in my life. And that's what strategy is. It's those 5 components right there. Assess, identify, research and investigate, brainstorm, and plot. And the same exact thing can apply to your case. I don't care if you're fighting for full custody in a 50-50 state, if you're fighting a parental alienation case, if you're fighting false allegations of DV, or if you're alleging DV, I don't care what it is. Strategy, having a strategy will help you 1,000%, not 100%, 1,000%. Take some time to develop a strategy. Going in with evidence that's all over the place is not a strategy. But how did you get there? How did you decide which evidence to show? That's what strategy is, taking every key component of everything that's going on and fitting it all together, or working with it all together and coming up with a plot or coming up with tactics. So what does it mean to assess your situation? It means asking the question, where am I? This part can be really hard and can be really painful, to sit back and listen to yourself and come up with exactly where you are financially, personally, physically, spiritually, emotionally. Where are you? What is your life? How would you describe your life right now? If you looked at all of these facets of your life, how would you describe your life right now? Why does it matter? It matters because guess what? If you're financially strapped, or if you're mentally stressed, or if you're spiritually just downtrodden and beaten down, guess what? It shows up when you show up in court. It does. In some shape, form, or fashion, what you're feeling, what you're going through in all of these aspects of your life, it shows up in your petition. It shows up in the way you negotiate or not negotiate. It shows up when you go before the court. It shows up when the guardian ad litem meets with you. Trust me, I've been doing this 20 years. When I meet with people on Zoom, within the first 5 or 10 minutes, I can pretty much tell where they are. Unless they have to share with me financially where they are, but personally, physically, I can pretty much tell where they are. And that's the point of me meeting with them through Zoom, so I can identify which areas they may need to work on, so that when they do show up in court, when they do show up with the guardian ad litem, when they do write their petitions and emotions, that it reflects a space that they believe that whatever they're asking for, they deserve it. They're worthy of it. They're ready for it. They're prepared for it. So you have to ask yourself that very honest question. Where am I? Are you physically able to fight in court for parental alienation? Are you spiritually? Are you in a space spiritually where you can go in and deal with the accusations of having being abusing your significant other or soon-to-be ex? Be honest with yourself. And if there's any changes that may be coming along at some point in the near future, you can actually factor that in, but don't do that yet. You always start with where you are right now. Honestly, guys, I would journal where I am. I would do this regularly if I were you. And then once you've answered where am I, then if there's changes coming to maybe your living space, if those things might be coming down the pipe, then I would add that later. But I would always start with where I am right now. And the reason I say this is because you don't want to hang your hat on anything that's not in existence right now. It may be really helpful to you later on, or right now, you need to be honest with where you are right now. And then you identify the other party's motives and their agenda and their why. You have to try to gauge as much as you can from the other person's real motives, their current circumstances, their current truth. You know why? Because that's how you come up with strategy. When you're getting to the plotting stage, you're gonna need to know what the other party has against you, what they have in favor of themselves, their truths, what is their financial predicament, what's their mental status. And you're not doing it to go into court and say, yeah, he or she has just been diagnosed with bipolar or borderline personality disorder, and because of that, I need to have full custody. That's not what we're doing here. We're doing it to plot. Yes, plot. I prefer plot. Some people have told me, oh, that's a bad word. It's not in my eyes. I plot. So it's a matter of perspective. But for me, it's about plotting. And plotting is not necessarily a negative thing. When you're competing, and that's what you're doing, you're in a competition right now. That's what you have to do. You have to plot to win, right? You have to plot to get the advantage. And so you have to identify. And a lot of people don't get the chance to do this because they don't, and I understand, because they're suffering from PTSD or CPTSD and they can't have any sort of contact with the other party or communication with the other party. Use an agent, use something else, but you have to get into the other party's head. You have to understand what their true motives are. If you could pretty much zoom in on exactly what their current predicament is, what their motives are, the better you can do that and be precise, the better it is, and the more cohesive and solid your game plan will most likely be. What do they want? What do they really want? And why? Why do they want that? Why are they asking for it? Are they doing this just to antagonize you and intimidate you and bully you into capitulating? Or are they really thinking that they could get what they want? Or are they doing this just because they don't want to pay child support, or just because they want to have a new paramour step in as the new parent? What are their real motives? Again, that's not something you need to disclose to anybody. Sometimes you find this information out and you run into court and you just blab it all out, and that is not strategic at all. That is not strategic. Means knowing when and how to use exactly that's where plotting comes in at. And then you research and investigate. You always research. You always ask questions. You always keep your eyes open, your ears open. You always keep your eyes glued to the glass to see what's going on. You always keep your ears glued to the glass to hear what's going on with the judge, with the lawyers, with the court staff, personnel, with the guardian ad litem, with the other party, whoever may have any sort of impact on your case. That's important. But you should always be looking for answers. I don't mean asking other people for answers that you can find on your own. That's not how you research and investigate. You research and investigate by looking for yourself. If you're looking for a court rule of procedure, go look for a court rule of procedure. Go to justia.com. Justia.com has statutes, has court procedure rules. And I think it even has lawyers on there. But I use Justia all the time because it's a very good resource. I'd rather you go there and look for yourself and then come back and ask, me or someone else, hey, what does this mean? That's being strategic. Being strategic is not being spoon-fed information. That's not how it works. You brainstorm. What does it all mean? Now is the time to put all those pieces together. All of what you came up with about your own situation, all of what you found out about the other party, all that you found out about researching and investigating, researching the rules and the laws and researching the judge and the court process and investigating who the other party's living with, where they work, who are they exposing your children to, where do they travel, who are their family members and where do they live. When you have all that together, you sit down and you brainstorm. Okay, let me map this out. Let me brainstorm and figure out what's really a challenge, what's really a weakness, what's really a threat, and let me see how I could either diffuse them, get rid of them, fix them, repair them, or work around them. That's what brainstorming is about. It's about deciding what really is in your favor, what isn't in your favor, what's in the other party's favor, what's not in their favor, and what can you do with what you have to change what's not in your favor. What can you use that you have to basically annihilate whatever it is in their favor? The brainstorming part of strategy is the most work because it does take a lot of critical thinking, analytical skills. It takes a lot of, if you're not inherently a critical thinker, it may take a bit of work and effort, but it's not impossible. You can train your brain to become much more of a critical thinker. And what can you come up with? Well, you could come up with a plan. You could come up with action. You could come up with tactics, whatever it takes to position your case and yourself so that the court is more inclined to listen to you, believe your version, and award you exactly or close to what you're asking for. And this is my favorite part. We're plotting. Plot your next move. I'm always plotting. I am not a woe is me kind of person at all. I do not stay down for long at all. And anyone who has worked with me know that I'm not. I'm fighting. We're going out fighting. I don't know if it's the native New Yorker in me or the fact that I'm a Leo, sun, moon, and rising, but I am not. I'm always plotting. Because plotting is where the action is. Plotting is where, you can pretty much put out what all the effort and all the work that you've done. Plotting shows what you've been doing, what you've been working on. You're plotting now so that you can, because especially when you make decisions to move preemptively, that means you'd make a decision to make a move based on what the other party's going to do or say or bring up. So if you're in court and the other party made a claim that you are, when the child is with you, you don't answer calls, you don't allow video calls, you're somewhat on the tepid side of parental alienation. Okay, so if they started out with that claim, they're probably going to make a claim down the road that you've done even more extreme or more adverse things to basically make parental alienation even more of a problem, more of an issue. So how do you move preemptively? You anticipate those additional claims they're going to make, and you get in front of that before they even make them. How do you do that? Well, you start documenting differently, or you start having witnesses with you, or you start spearheading the calls and the visits. That's how you act preemptively. That's plotting your next move. So there are some strategic behaviors. If you can start to think strategically, speak strategically, and make strategic moves, eventually it will become almost like second nature for you. And every time you go to court, or every time you're brought back to court, you'll get better and better at plotting, at preparing, and at presenting your case. You won't be intimidated just from the mere sight or the mere threat of being brought back to court. It won't have the same effect anymore. Even in cases where legal abuse, it won't affect you as much anymore because you'll be ready. You'll always be ready. You'll always be in a position where you can actually put forth the best and the strongest case if you start to think, speak, and move strategically and practice it in your daily lives. And because at some point, like I said, it'll become like second nature. Think strategically. That means thinking outside the box. Some of you are really black and whitish, and everything is not black and whitish. Some things, it really helps to listen to other people's stories who have nothing in common with you. It really helps to just listen or watch people who have absolutely nothing in common with you. And I'm not just talking about family court stuff. I'm just talking about life in general. It helps you think outside of what you've been used to thinking. It helps you to see things from different perspectives. Once you're able to see things from different perspectives, you're able to come up with things much easier. You're able to think outside of the box. You're able to be much more creative and resourceful. Always ask questions. The key though is don't ask stupid questions. Don't ask questions that you can find the answer to on your own. That doesn't challenge you. That doesn't push you. It doesn't help you. Ask questions that have a specific intention in mind. They have a specific reason for you asking the question. Always ask questions. Don't be scared to ask questions. But know when to ask what question. You're not going to ask a judge. That's not the judge's job. Go ask the court clerk how to file a paper with the clerk. Because they're already making an opinion about you. Believe it or not, they are. And the more you give them the impression that this is where your focus is, the more they're going to minimize or downgrade your position or your argument. A lot of judges look for opportunities to just treat you like a subhuman. And so don't give them any reason to do that. Some of them are going to do that regardless, but don't give them any reason to do that. Formulate your questions based on exactly what it is you're trying to achieve. If you can get the answer on your own, try that first. But ask questions that are meaningful, that have a purpose. Pay attention to all the details. Watch everybody. I watch everybody. I watch the court reporter. I watch the judge. I watch the parties. I watch everything and everybody. You know why? Because if there's something that I think I could use when I'm plotting, that's what I'm going to find. When I research and investigate, that's how it comes up. I'm paying attention to everything, all details. Learn to use it wisely. Learn to focus your attention on things that really matter. Pick your battles. I am big on that. Pick your battles. Not every battle is worth fighting. Some battles you are going to lose, and that's okay. It's the war you're trying to win. Be flexible and be open-minded. Be flexible with what the other party's asking for. Be flexible with what the judge is suggesting. Be flexible with what the attorneys are saying. Don't be so resistant. Be flexible. You know why? Because a lot of times when people make a recommendation or a suggestion, there's usually an underlying message in there. There's usually something underlying that you could use to your benefit. So, instead of shooting them down immediately, consider it. Consider your version of what they're asking for. That's what it means to think strategically. Speak strategically. When you're asking those questions, ask open-ended questions. Ask questions that require the person to basically have diarrhea of the mouth. Because even if they speak for 20 minutes and only 5 minutes of it, what they have to say is pithy, then you have 5 minutes of valuable info or intel that you could use at some point. Trust me, the key is knowing when and how to use it. Speak with a specific goal. Some people just talk just to hear themselves talk. I am not one of those people. And I don't have a lot of patience for people who talk just to hear themselves talk. And I know it's rude, but I will cut you off if you're just talking just to hear yourself talk. Let's speak with a goal. What are you trying to say? Because guess what? When you go in court, again, and you're talking and you're speaking with a goal, with an intention that the court specifically has an interest in, they're going to defer to you much more than the other person who's not doing that. Trust me, they don't want to be there. The judge does not want to be there. They certainly don't want to hear you ramble. They hear that stuff every day, all day. Speak with a specific goal in mind. Have something to say. Be discreet about your intentions, though, as I mentioned before. Never reveal everything. Don't overshare. Don't talk too much. If you're a rambler, then my suggestion is you find some technique, whether it be one of those palm stones or, a visualization exercise, whatever it is. If that doesn't work, then you might have to hire a lawyer, because rambling is so detrimental. Going to court, it opens up so many cans of worms, and it leads to stuff that you didn't want to share, or that the other party uses to their advantage, or the court misinterprets. If you're a rambler and you can't get that under control, you might want to hire an attorney. Always make the other person comfortable when you're speaking strategically. You know why? Because if you make them comfortable, you make them feel good, they're more inclined to listen, they're more inclined to believe you, they're more inclined to actually be in your favor. And the last one is don't overshare. Speak, say enough that it accomplishes your goal, your mission. Don't overshare. Only provide the necessary information. And I see people do that so often in family court. They'll provide all these details. You don't have to go back. You're oversharing. Listen to the judge's questions, pay attention to the judge's reaction, and then that way you'll know when to share more information, or when to volunteer more information, or when to ask questions that elicit additional information. But I wouldn't start off with that. That's a little different than rambling. That's the information that you think is pertinent is extra. That's different than rambling. Rambling means just going in there, just talking about anything and everything and getting nervous and anxious, and you just keep talking. Get your stuff together. Get everything together. Make sure everything is in order. All the things you found, all the things you've amassed, you've accumulated, please put it together in an organized system that you understand. Please take the time to do that. It's extremely important. And map out a plan. Always have a plan. Every single time you go to court, every single time you meet with the guardian ad litem or a mediator, have a specific plan. I was meeting with someone last week preparing for trial, and they really thought they had this plan all mapped out. And I had to shoot the entire plan down because it wasn't a plan. A plan is something that has a purpose, it has an intention. You've identified what you need, what you want the plan to do, what the issues you want it to address. That's what a plan is. It's not just putting stuff together and saying, yeah, this is what I'm going to say when the judge says this. This is what I'm going to say when the other party says this, because I wanted to prove this. This is what I'm going to say when the other party says or shows this, because I wanted to prove that. There's a difference. And then have a backup plan. Always have a backup plan, because sometimes things are not going to necessarily work out your way the first time. That's fine. That's okay. But if you've already thought about the possible consequences and the possible outcome when you were plotting, then you probably should automatically have a backup plan. Because anytime you plot, part of your plotting should be, okay, if this doesn't work, then this is what I'm going to do. Or if the outcome is this, or if the judge does, this is what I'm going to come up with as a fallback plan, as a backup plan. Prioritize things. Make sure when you're getting everything together, you make sure things are you prioritize things. When you do the best interest of the child factors analysis for yourself, that means taking the best interest of the child factors for your specific state and going through each one of them with your background and your facts. Even if your situation or your case entails all 15 of the 15 factors, if that's how many your state has, they're not all going to be as important as others. You're prioritizing things because every time you go to court, you're not giving this endless amount of time to talk about your case or talk about what's going on or talk about what's happened or talk about what you want. Your time is limited. So you want to maximize the use of your case. And that's being strategic one-on-one. And then analyze how things went, how things resulted, what the outcome is, and then go circle back and start all over again. Making strategic moves means sometimes redoing things, revamping things. And I know it sounds like a lot of work, Tracey. It is a lot of work. But you know what? Your kid's worthy of it, right? They deserve it. They deserve whatever it takes. I am not a fan of people who give 100% of the power and control to attorneys while they sit back and all they do is show up or complain about the co-parenting stuff. That's the easy way out. So that when things don't turn out the way they wanted to, they can blame somebody. Because what I do is not just to help you win, it's to help you develop some skills so that in the future, you're ready, you're prepared, you can present, you can position in the future, whether you work with me again or not. When you show back up in family court, whether it be you bringing the other party or the other party bringing you, you need to be ready. You need to not be intimidated. You need to feel confident and competent enough to move forward. And that's exactly what it is I aim to do when I work with people. So the impact of using strategy is going to vary from lane to lane. Lane is the phase of your case. Lane 1 is where you are in the deciding phase, where you're either being threatened to go to court or you're thinking about going to court for the first time. The ones who are just fresh, they're green to the whole family court system. That's lane 1. And then lane 2 are the ones who have filed a petition or have been served and mediation is coming up or the first court appearance is coming up or it's immediately after that. So you're pretty much still kind of new, but not quite. Because at this point, you've probably done some research and you understand a little bit about the process. You have a little bit more insight about what the other party is really looking for, trying to get, and their motives. And then there's lane 3, where you've been in family court for 6 months or more. You might have motions pending, you might have contempt pending, you might have, or the other party might have to report on supervised visitation or substance abuse treatment or mental health examination or anger management classes or therapeutic visits. That's lane 3. And lane 4 are the ones who are pretty much going to trial. They're gearing up to go to trial. And so the impact of strategy is going to be a little different for each stage, because each stage, the goal for you should be different. And not to say that they won't overlap, but if I can get you to understand that there's some things that are critical for different stages or phases of your case, then it's easier for me to explain to you why you need to do certain things you need to do when you're in specific lanes of your case. And again, you could be in lane 2 and 3 at the same time or lane 3 and 4 at the same time.